let me ask you something. Who's really in control of your startup? You might be the founder, you might have built the business from scratch, but once you bring in investors, the power dynamics can shift fast. Suddenly, big decisions might be made without you. Strategies could change. Even the future of the company could be steered in a direction you never agreed to. That's why you need legal protections in place. Protections that give you the power to veto key actions, appoint directors you trust, and keep your vision at the center of your company's future. In this video, I'm going to walk you through exactly what your founder rights are, where they should be locked in, and how to negotiate them so you stay in charge for the long haul. I'm Damin Murdock, principal lawyer at Leo Lawyers. You may know me personally, or this is the first time visiting our channel. For those that know me, this looks and sounds like me, but it is actually an AI avatar. The video you will watch today is based on a script that has been written and reviewed by the real me. However, it should only be considered general information and not legal advice. Now let's talk about startups. Startups are built on ideas and leadership, but if you don't lock in legal control early, you risk losing your voice in the very business you created. So let's talk about how to make sure you stay in charge. Let's talk about shareholders' agreements. A shareholders' agreement is a legal contract between the shareholders of a company. It sets out each shareholder's rights, obligations, and how key decisions will be made. If a shareholder breaches that agreement, the company or the other shareholders can take action to hold them accountable. But this agreement isn't just about compliance, it's about clarity. It sets the rules of operation between everyone involved, so you have something to point to when disagreements come up and a path forward when you hit a deadlock. One of the first essential clauses is about appointing and removing directors. The agreement will typically say who has the right to appoint a director. For example, it might say the founder can appoint a director as long as they hold 10% of shares, or it might say any shareholder with more than 25% can appoint one. This clause matters because directors make most of the day-to-day decisions. Only major strategic choices go back to the shareholders. If you're a founder, you should absolutely consider including founder rights in the agreement. These give you extra legal protections as the business grows. For instance, you can include a clause that says you can appoint a director as long as you hold 10%, or only your own shareholder group can vote to remove you, or other shareholders can't propose to remove you as their appointed director. That keeps your seat on the board protected. You can also go a step further and negotiate veto rights. Normally, directors make decisions by simple majority, which is more than 50%. If you have 3 directors, 2 votes is enough. But with founder rights, you can say certain key decisions can only be passed if the board votes by majority plus you, as the founder, give your affirmative vote. That gives you veto power over critical business decisions. The agreement also helps you control who becomes a shareholder. Let's say you issue shares to an investor. Do you really want them reselling those shares to a competitor later? A disposal clause gives existing shareholders the first right of refusal if someone wants to sell. You can also add restrictions like no selling to a competitor without the founder's written approval. There are often preemptive rights too. These say that if the company issues new shares, it must offer them to existing shareholders first before seeking external funding. This protects your equity from being diluted. Of course, there are carve-outs. For example, if the company is bringing in a strategic partner or issuing shares under an employee incentive plan, preemptive rights might not apply. These carve-outs should be clearly defined. Now let's talk about drag-along and tag-along clauses. In a real example from the Gold Coast, an entire apartment block was ready to sell, but one owner held up the deal. They used their position to demand better terms. This can happen in startups too. A drag-along clause allows the majority shareholders to force the minority to sell their shares on the same terms, so deals don't get blocked. A tag-along clause lets minority shareholders join in if the majority is selling, so they're not left behind. But if you're a founder, you may want to restrict drag-along powers. For example, you could require founder approval before anyone can force you to sell. Now, this part is crucial, the dispute resolution clause. Why? Because shareholder rights are governed by the Corporations Act, which is federal law. That means if you end up in a dispute, it usually goes straight to the Supreme Court in your state. And that means hiring both a solicitor and a barrister expensive. But a properly drafted dispute resolution clause can stop that. It can require shareholders to go to mediation first, where a third party helps resolve the conflict. And often, one full day in mediation, just 8 hours, can avoid months of court time and thousands in legal fees. The cost of drafting a shareholders agreement depends on how complex it is. If it's a straightforward agreement between two shareholders, you're probably looking at $1,800 to $3,000. But if you have multiple shareholders, each with special terms, or lead investors asking for custom clauses, that figure could rise to $3,000 to $6,000 or more. If you're serious about your business, protect it with the right agreement. Subscribe to our YouTube channel to learn more about founder rights, capital raising, and legal protection for your business. And if you need legal support drafting your shareholders agreement, contact us on our number in the description box. Thanks for watching.